Kinds of punishments. Kinds of punishments. The punishment for any offence under the Pakistan Penal Code, PPC, varies depending on the specific offence committed. The PPC provides specific provisions for each offence, specifying the range of punishment that can be imposed by the court upon conviction. Section 53 of the Pakistan Penal Code, PPC, pertains to the punishment to which offenders are liable under the sentence of a court. Kinds of punishments, U/S53 of PPC. The punishments to which offenders are liable under the provisions of PPC are as under: 1. Cases. 2. Diet. 3. Arsh. 7. Imprisonment for life. 8. Imprisonment namely I. Rigorous, that is, with hard labor. 2. Simple. 9. Forfeiture of property. 10. Fine. 1. Qisas. Qisas is a legal concept derived from Islamic law and is based on the principle of retributive justice. It refers to the right of the victim or their family to seek retaliation or retribution for certain offences committed against them. The term qisas itself means equality or evenness in Arabic. Under the concept of qisas, the punishment for an offence is equivalent to the harm caused to the victim. It primarily applies to cases involving bodily harm or loss of life. The goal of qisas is to provide a sense of justice and maintain social order by ensuring that the punishment matches the severity of the crime. In Pakistan, the provisions related to qisas are primarily derived from Islamic law and are incorporated into the legal framework. The main provisions related to qisas can be found in the Pakistan Penal Code, PPC, and the Qisas and Diet Ordinance, 1990. Examples of offences where qisas may be applicable include: I-sense murder. If a person intentionally causes the death of another person, the family of the deceased may have the right to seek qisas. The punishment, in this case, would be the equivalent punishment of causing the death of the offender, subject to certain conditions and legal procedures. I-sense bodily harm. In cases of serious bodily harm or injuries caused intentionally, the victim or their family may have the option to seek qisas. The punishment would involve causing equivalent harm or injury to the offender, as determined by the court. The relevant provisions related to qisas in Pakistan include: Qisas and Diet Ordinance, 1990. This ordinance provides the legal framework for the implementation of qisas and diet, blood money, in Pakistan. It outlines the procedures, conditions, and limitations for seeking qisas and settling offences through compensation, diet. Section 299 and Section 302 of the Pakistan Penal Code. These sections define the offence of murder and establish the distinctions between murder and culpable homicide. They provide the basis for determining whether qisas is applicable in cases of intentional killing. 2. Diet. Diet is a concept within Islamic law that relates to the payment of compensation or blood money by the offender to the victim or the victim's family in cases of murder. Diet means the compensation payable only in cases cattle and not in cases of hurt. It is payable only in cases where an offender guilty of cattle and is not liable to qisas or where is not enforceable. Value of diet U.S. 323 of PPC. The court shall be subject to the injunctions of Islam as laid down in the Holy Quran and Sunnah, and keeping in view the financial position of the convict and the heirs of the victim, fix the value of diet which shall not be less than the value of 30,630 grams silver. 3. Arsh. Arsh is the kind of compensation payable at the causing of hurt. Definition U.S. 299, b, of PPC. Arsh means the compensation specified in PPC to be paid to the victim or the heirs. Value of Arsh. The value of Arsh will be assessed at a certain percentage indicated by various provisions of the value of diet U.S. 323 PPC. Mode of payment. The arsh will be payable in lump sum or in installments spreading over 3 years from the date of final judgment. Failure to pay arsh. In case of default, the offender may be kept in jail to serve simple imprisonment until arsh is paid in full. It may be awarded in the following section. I sense Section 334 PPC. I sense Section 337 PPC. 4. Daman. Daman is an Arabic term that refers to compensation or blood money paid by an offender or their family to the victim or the victim's family as a form of financial restitution for bodily harm caused by the offender. Daman means compensation which is determined by the court as punishment against an act causing hurt not liable to arsh. It is a component of the Islamic legal system and is recognized in some Muslim-majority countries, including Pakistan. Value of Daman. The value of Daman will be determined by the court, keeping in view, 1. The expenses incurred on the treatment of the victim. 2. Loss or disability caused by the functioning or power of any organ. 3. The anguish suffered by the victim. 4. Ta'zir. Ta means punishment where the offender cannot be punished through qisas, diet, arsh or daman. Ta'zir is a concept that refers to discretionary punishment or penalties imposed by the court for offences not specifically covered by fixed punishments prescribed in religious texts or legal codes. It grants judges the authority to determine the appropriate punishment based on their understanding of the principles of justice, societal norms, and the specific circumstances of the case. Ta'zir punishments can include fines, imprisonment, public chastisement, or other measures aimed at maintaining social order and deterring unlawful behavior. 6. Death. The punishment of death, also known as capital punishment or the death penalty, involves the deliberate and authorized taking of a person's life as a form of punishment for certain serious offenses. It is considered the most severe and irreversible penalty in the legal systems of some countries. Death is the capital punishment that may be awarded for certain offences under PPC. Such as I. Waging war against Pakistan U.S. 121 PPC. 2. Murder U.S. 302 PPC. 3. Hijacking etc. 7. Imprisonment for life. It is a form of punishment where an individual is sentenced to spend the rest of their natural life in prison for committing a serious offense. In Pakistan, sentence of imprisonment for life means remaining is the span of the natural life of the convict, which is accepted as being of 25 years duration. PLD 1968 La. 1. Following are some of the offences where they may be inflicted as punishment. I. Sedition U.S. 124 APPC. 2. Counterfeiting Pakistan coin U.S. 232 PPC. 3. Punishment for murder U.S. 302 PPC. 8. Imprisonment. Imprisonment means the confinement of convicts within certain prescribed limits. The maximum period of imprisonment that can be awarded for an offence is 14 years U.S. 55 PPC and the shortest term provided for an offence is 24 hours U.S. 510 PPC. I. Kind of imprisonment. I. Rigorous 2. Simple I. Rigorous. In the case of rigorous imprisonment, the offender is put into labour such as digging the earth, drawing water etc. 2. Simple. In the case of simple imprisonment, the offender is confined to jail and is not put to any kind of work. 9. Forfeiture of property. Forfeiture of property refers to the legal process by which assets or property are seized by the state as a punishment for involvement in criminal activities. It serves as a deterrent and aims to disrupt criminal networks, remove proceeds of crime, and compensate victims. Forfeiture of specific property may be awarded as punishment in the following section. I. Section 126, PPC. 2. Section 127, PPC. 3. Section 169, PPC. 10. Fine. Fine is a common form of punishment imposed by the courts for various offences. A fine is a monetary penalty that an offender is required to pay as a consequence of their unlawful actions. The amount of the fine can vary depending on the severity of the offence and is determined by the court within the limits prescribed by law. The fine is the punishment which may be awarded in some offences along with imprisonment. The fine is the only punishment provided for in sections 137, 154, 155, 156, 171g, 171h, 171 1.278, 283, and 290, PPC. Sentence of imprisonment for non-payment of fine U per second 64. In every case where a sentence of fine is awarded, whether it is along with imprisonment or without imprisonment, the court may direct that in default of payment of the fine, the offender shall suffer imprisonment for a certain term, which shall be in excess of any other imprisonment to which he may have been sentenced or to which he may be liable under a commutation of a sentence. Sentence of imprisonment not to run concurrently. A sentence of imprisonment in default of a fine has to be served separately. That sentence cannot run concurrently with any other sentence. Limit of imprisonment for non-payment of fine U, Sec. 65. If the offence is punishable with imprisonment as well as a fine, the term shall not exceed 1/4 of the imprisonment which is the maximum fines for the offence. 8. Limit of imprisonment for non-payment of fine U per second 67. If the offence is punishable with a fine only, the imprisonment that the court imposes in default of payment of a fine shall be simple and the term shall not exceed the following scale. Amount of fine. Term of imprisonment in default of payment of fine. I. Not exceeding 2 months and Rs. 50/. 2. Not exceeding R'(S.100/. Not exceeding 4 months. 3. In any other case not exceeding 6 months.